All rise. Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in 1 CACV 230692 Green Cross Medical versus Karen Mangisi. Counsel, we have read the briefs. We've conferenced this case this morning in conference. We're looking forward to the argument. Both sides have 20 minutes to present their case. I would remind appellants that if you wish to reserve any time for rebuttal, that's on you. And we are live streaming this as well as recording the argument here today. So as you approach the podium, if you would announce your name and the party for whom you represent. And with that, we'll hear from the appellant.
Thank you and good morning, Your Honors. I'm Isabel Humphrey with Hunter, Humphrey & Yavitz. I'm here today representing the Galley Family Trust, and the original trustee was John Galley, who passed away a couple of years ago. With me today are two of his children, Karen Mangisi, the current trustee who's named in the caption, and John Galley, his son. Your Honors, we have 4 issues here today, and I obviously want to spend most of my time addressing the questions that you may have about those issues. So I just briefly, I want to say this case involves an elderly gentleman, John Galley, who was manipulated, frankly, by an attorney who was working for her son and her daughter-in-law, who were competitors to Mr. Cunningham's client, Green Cross. Her son and daughter-in-law's company was called Compassionate Care Dispensary, and they wanted to start a dispensary in Winslow. And Mr. Cunningham's client, Green Cross, also wanted to start a dispensary in Winslow. John Galley owned one of the only 2 small properties in Winslow that was properly zoned for that sort of endeavor at the time. And this is right at the beginning of Arizona's medical marijuana practice, the experiment, I guess we can call it at this point. And so nobody really knew how this was supposed to work. But John Galley had entered into a lease, a $900 a month lease with Green Cross, with Mr. Cunningham's client. And within a very short time, a week or 2, he was convinced by the Compassionate Care Dispensary attorney to back out of that lease for fear of being federally prosecuted. This is a federally illegal business. And immediately there was a lawsuit. Immediately Mr. Cunningham obtained a temporary restraining order. Within a very short time, he obtained a preliminary injunction, And the competitors, Compassionate Care Dispensary and Green Cross, proceeded to go to the Department of Health Services and attempt to get permission to open the dispensaries that they wanted to open. Both of those companies arguing that they had a right to use the Galley Trust property. At that point, Mr. Galley sold the property to Compassionate Care Dispensary's sister company. I believe it was Western Surety. There are a couple of companies involved.
And just to be clear, I think that your briefing tells us that in multiple places that your client is not taking issue with the factual determinations that the Superior Court made.
Correct.
And we're very familiar with the chronology. So, and so I want you to speak to, given those, I see that your argument basically is to how we should view this case, whether as an abuse of discretion, whether there was reasonable evidence to support, or a de novo review. And you say, because we don't have any factual issues with the findings of fact that they made in the Superior Court. But I'm having a hard time kind of teasing out the difference between what a factual issue is and calling it a legal issue. For instance, the court found that that Green Cross, I've been calling it Green Choice the whole time, Green Cross didn't know until 4 days after ADHS required them to finalize where they wanted their $150,000 deposit to go. It was 4 days after that deadline that they learned that there was a new owner. And that's a factual finding made by the court. And so then it kind of circles back around to, well, there are other parties to blame. And I think your causation argument is largely based on it was either their attorney or it was their attorney in cahoots with Western Surety, in cahoots with CCD, whatever the case is. But to me, when I keep going back to your statement that we're not disputing the facts, and then I read the facts that the court laid out, I have a hard time finding that to be a legal issue.
Your Honor, I don't believe that there was a finding of fact that Green Cross didn't learn of the new...
No, not learn of, but I think, they were on notice at the preliminary injunction hearing that they were intending to sell, and I know there was a filed document, but I'm saying that they got written notice that because this has been sold, you need to get the permission of the new landowner as part of us substantiating that your file is complete. They didn't get that notice officially that they had to do something additional until 4 days after they had to pledge that $150,000 to a CHA outside of Winslow. So again, I understand that leading up to that, there may have been various places where they might have known there was going to be a sale, but there was also a lot of interaction between all these parties about whether their application was complete, whether it wasn't, and they got that notice 4 days after, there's a new landowner, and you're going to have to get that new permission. How does that then fall back on a factual basis on Green Cross?
Your Honor, we don't dispute when ADHS informed Green Cross of the various requirements. The parties had stipulated, in fact, to that fact as well as almost every single other fact in the case, if you read through the joint pretrial statement. The causation argument, the first issue in the briefs, everybody agrees that the reason that Green Cross was excluded from that lottery drawing for Winslow was because they withdrew from that lottery drawing, effectively, by saying, please post instead our proof of deposit toward the Kingman lottery. So they withdrew from that lottery. I believe it was, Exhibit 22, that was on...
But their argument is they did that as a result of the cascade of events that happened at the point of the lease.
The cascade of events that you were just talking about, Your Honor, happened after Green Cross withdrew from the Winslow lottery.
Well, the breach happened before.
The breach happened before.
And there was certainly room in those time frames where ADHS was giving them notice that, I understand they pledged that money in June, but there was a date in July where ADHS says, okay, you're going to have a drop dead date of whatever, July 26th to tell us where the final, they pledged it in June, but then they had some period of time where they could have changed it. And DHS gave them one final email correspondence, I think, saying if, the deadline for choosing where you want this money is today or tomorrow or whatever. It was a very short period of time.
And the point, from a causation point of view, is you say this can't be placed on Green Cross. It can't be placed on Galley Trust either.
Sure it is. They breached. They breached, and there was an obligation on behalf of of Green Cross to mitigate any potential damages. If they'd have drawn out on the Kingdom in the Kingman lottery, then the damages are mitigated. But the point being is they breached.
Right.
They took all reasonable steps. They filed suit. They did everything else to try to remedy and stop your client from breaching the agreement.
But the causation, Your Honor, of Green Cross withdrawing from the Winslow lottery, there were two causes. There was this zoning argument that Catherine Ward was making very clearly on behalf of Compassionate Care Dispensary.
Well, you say very clearly, but that's not in line with what the court found. The court found, and you've told us that you don't disclaim any of their findings, that there were things she was doing that was acting on behalf of your client, including reaching out before the June 8th hearing and contacting government agencies to get them to do something that was against Green Cross's interest on behalf of Galley. So again, I just want to stay with what you've said, which is factually you don't dispute what the court has found, and the court found that Catherine was acting and I understand there's more of a legal argument about what agency was, but your client never disclaimed her as their attorney. You went through this whole preliminary injunction hearing. No one stopped and said, I don't want you, you can't be my attorney. You're playing games here.
Your Honor, as far as Exhibit 44, as I mentioned in the brief, this was admitted, this was the only document on which the judge relied to say Catherine Ward was acting on behalf of Galley Trust when she addressed the zoning issue. Exhibit 44 was admitted on a limited basis, right. And the judge made a discussion on the record about how under Evidence Rule 801D2, he couldn't rely on that alone to find agency. And then in his findings, he did. So that was a legal error
but there was
that
more
he had
than
acknowledged.
that. I mean, you've admitted in your briefing that she was clearly an agent at some point in time.
Of course, for the litigation. She could not have been Galley Trust's agent.
If she exceeded the agency relationship, isn't that a legal malpractice action against her after this is all concluded?
Your Honor, she did not exceed the agency relationship. All of these communications she had with ADHS are in the context of the ADHS proceeding, in which Galley Trust is not only not a party, but has no interest. Once the land has been sold, Galley Trust could not care less who gets this dispensary certificate. And third, Galley Trust is not even permitted to know what is happening in front of ADHS due to their confidentiality provisions. Galley Trust has no legal rights, interests, or participation whatsoever before the ADHS proceeding. And so when Catherine Ward very clearly in every single communication with ADHS expresses that she's acting on behalf of her son and daughter-in-law's company, Compassionate Care Dispensary, that is a separate representation of a separate client whose interests, quite frankly, conflict dramatically with the interests of Galley Trust. And there's no overlap between those. There's overlap factually between the situations that she's addressing to the one tribunal, which is the Superior Court on behalf of Galley Trust, allegedly, and the situation she's addressing in front of the ADHS, a proceeding to which Galley Trust has no right to even find out what she's been saying or what's happening in that proceeding. And Your Honor, I think going back to the question of whether this causation can be laid at the feet of Galley Trust for breaching the lease. Galley Trust did breach this $900 a month lease and then immediately sold the property to Ms. Ward's family company, Western Surety, washing its hands of this whole business, quite frankly.
Don't we look at damages at the time of the breach?
As far as calculating the amount of damages, yes, Your Honor, but the causation here, everybody agrees that the causation here, the immediate cause of the exclusion of Green Cross from the lottery is Green Cross deciding to withdraw from that lottery. And they say, well, the reason we decided to withdraw is because Catherine Ward brought up this zoning thing, which was resolved, actually. ADHS determined that was an error. But more importantly, Your Honor, is
could
the...
Green Cross have submitted an application without the lease for the Winslow area?
They had the lease, Your Honor, and they had a
I
court
know
order.
your client breached it. So
Well, I understand.
after the breach,
Sure.
After the breach, they had no lease because there was a breach. So could they then submit?
Yes, Your Honor, they did. They still were submitting because they had a preliminary injunction saying they were entitled to the property. The problem came when the new owner, Western Surety, the son of Catherine Ward, directly communicated with ADHS and said, we, the new owner, do not consent to Green Cross being on this property. They had no right to do that. They were bound by the lease as much as Galley Trust was bound by the lease. We've stipulated to that. We stipulated to that prior to trial. Western Surety was bound by the lease. Western Surety was bound to give ADHS correct information. Mr. Cunningham did provide ADHS with the injunction, but his client decided once there was a new owner and the new owner wasn't going to abide by the lease, he didn't feel comfortable going through with the lottery, was his argument. But Galley Trust cannot be held responsible legally for what the new owner decided to do, that the new owner decided not to follow the legal requirement to follow the lease. Galley Trust sold that property, got out from the mess, and could not, by the way, could not be involved with the ADHS proceeding, had no legal right to say anything to them or even know what was being said to them, or even know who had applied for a dispensary certificate. It was not public information. Your Honor, I want to reserve some time for rebuttal. I do want to briefly touch on some of the other issues, but in particular, the last issue in the brief. It's only the last issue because it's the least, there's the least in the record about it, but we had a stipulation on the record that management fees were not being sought as part of the damages here. That Green Cross recognized that if there's amounts that they were going to pay out in management fees, that's an expensive operation. That's not lost profits, or lost surplus perhaps is a more appropriate phrase when you're talking about a nonprofit organization. We had a stipulation on the record that management fees were not to be included in damages. The expert acknowledged that he assumed all along that essentially all of what he called lost profits were actually expenses of management, would have been paid to a for-profit management company and not retained as surplus. The trial court made no findings in that regard. I think, frankly, he just had forgotten about the issue by the time he did the findings. There were no findings in that regard, but there was a stipulation on the record. It makes absolutely no sense for Galley Trust to have to pay Green Cross for the management fees that Green Cross avoided. These are avoided expenses of operation of a business that never opened. Your Honor, I'll reserve the remainder time for rebuttal.
All right, thank you. Mr. Cunningham.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court. My name is Whitney Cunningham. I'm with the law firm of Aspie, Watkins, and Diesel in Flagstaff. I'm here today on behalf of my client, Green Cross Medical, Inc. The principal of my client lives across the country, so he's watching on the live stream, and I appreciate the court allowing that to happen. I'd like to directly address some of the arguments that counsel has made, but I'd like to start with just a quick overview of how I see things shaping out, because, of course, there was a lively discussion about the fact that the court's findings are not being challenged, and therefore the question is there really a meaningful legal argument for the court to decide today? The reply brief is telling in this regard. In the reply brief, there was only 3 pages that contain a meaningful legal argument with case citations in this type of thing, the type of thing that you would think you would see if you were really rolling up your sleeves and trying to parse the legal questions. In fact, in this 36-page reply, the entire second half of the brief contains 1 legal citation of any kind. It does contain about 13 pages of trial testimony that's lifted and pasted into the brief, which, by the way, isn't counted in the word count. We actually have an over-limit brief, but that's not a complaint, but a point of emphasis that what's really going on here, understanding that the facts are lost to this defendant, can they somehow be conjured into a legal position? And I think that the answer is no, and I think that the structure of the reply brief itself sort of gives that away. I think what the Galley Trust would like, in part, is to convince this court to reweigh facts, and in part to engage in some thought experiments. But when you tie the law to the facts as found by this finder of fact, the trial judge, the outcome in this case is logical and supportable.
Can you just, because it was the last thing she said, so it's still on my mind, the management fee issue and the
Certainly.
stipulation and the fact that we don't really have any findings regarding why those were included or not. And I'm familiar with the experts' take on that, but why if you had a stipulation and there's no factual finding by the court, what are we to do with that? I understand, no, but you don't have to. Your expert said, that is one way that companies do this. They can have
Right.
management companies. There wasn't really specific testimony that was the exact plan. There obviously wasn't a company, so we don't know how they were engaging in the business. But can you talk a little bit about that?
Certainly. First of all, I'll dispute the contours of any so-called stipulation. This has not been laid out in the briefing. Rather, what counsel is attempting to do is refer to some testimony which is cited in reply to support this notion that a nonprofit can't have profits. And there are a couple of facts that I think are important.
And I think they admitted at trial they could. I mean, that.
Well, yes, but the argument is circular.
Okay.
And here's why. Green Cross's expert, Dwight Duncan, did a damages calculation where he calculated revenue and he subtracted expenses. He calculated the cost of goods sold, he calculated operating expenses, and subtracted these out. And he wound up with a net profit margin, 30-40%, something along these lines. The trust expert, Mr. Tribe, made no adjustment
Right.
to those calculations, right? So what we're talking about is what in any other company would be a profit margin. Now, in a for-profit company, that might be paid out to shareholders. But as a nonprofit under Arizona law operates under rules in terms of what it can do and what it can't do. In the line of questioning to which Ms. Humphrey refers, she herself makes the point, and I'm at page 29 of her brief, where she's questioning my client and saying, and these are her words, quote, because of the nonprofit requirement, most of these profits would be paid out to a management company. And she's trying to get the witnesses to go along with this point. Mr. Duncan testified that that is a model, that he is aware of other models, but that's not anything that ever came to fruition in this case, because how Green Cross would have expensed or used its profits, we don't know. And this is a critical point. The parties stipulated, and I think it's finding of fact number 7, that the ADHS requirement isn't that all profits must be used for business expenses, but rather all profits must be offset by, quote unquote, an expenditure. And it's simply fallacious to equate expenditures and business expenses. Mr. Duncan's profit calculation showed what was left over once you received revenue and subtracted out all of the dollars necessary to get to that point. This idea that a nonprofit must continue to incur expenses until it is down to zero is not well developed in the record. The judge cut it off at about the point where the quoted testimony in the reply brief ends. He found it to be irrelevant, and what we cite, and I think where the court came down is, you can't start treating a nonprofit as if it can't earn a profit, because that simply invites the breach, right? I mean, that's why we point out the Girl Scouts have every right to earn $1 on their cookies, as does Nabisco. And if their contracts aren't any good, then that's just commercial chaos. Just one more quick point. Testimony was also developed briefly that these monies don't necessarily go to management companies. They could be reinvested. They could be used for research and development. They could be used for education. It's the whole universe of possibilities of how a nonprofit corporation might use its profits consistent with Arizona law. And it's simply not a point that became relevant to the finder of fact, because the question in this case was there causation and were there lost profits? And then once that was determined, what a company properly operating in Arizona would have done was not an element in this case. All right. I'd like to address on the issue of causation, the notion that somehow the trust attorney was rogue and should be blamed and not the defendant. So Mr. Galley, now deceased, was not an elderly and manipulated individual. He himself testified that he was a sophisticated landlord. This was at the preliminary injunction hearing in June of 2012. He owned something like 60 properties at that time. He was aware that his attorney was interested in the medical marijuana business. He testified that his own son was interested in the medical marijuana business. Importantly, he testified that it was his decision to cancel the lease, that he changed his mind, that it was his decision to change the locks. He then, on May 21, signed an affidavit stating under oath that Green Cross Medical had no rights in this property. And that was a false and incorrect statement, but he signed it under oath. Even after being ordered by the court to restore possession, he did not do that. All right? These are all things that Galley Trust trustee personally did and testified to. This is what started the ball rolling. Subsequently, on May 25, on May 26, his attorney is contacting the city attorney in Winslow, seeking to develop evidence in support of her case or her defense as it was getting ready to go to the preliminary injunction hearing. In other words, she was doing and saying things that were completely consistent with what her client had already said and done. And at the preliminary injunction hearing, Mr. Galley testified that she had been his attorney for several months, at least since February of that year. She was the attorney for the trust throughout this period of time, April, May. She represented the trust at the preliminary injunction hearing, and after the preliminary injunction hearing, this case went up on appeal for the first time, and she represented the trust at that appeal. The fact that the trust attorney was or may have been doing other things on the side, first of all, were known to Mr. Galley. He testified to that. And secondly, that he had thrown in with them for financial gain. When Ms. Humphrey talks about the fact that the property got sold, that's because they paid him a bunch of money. It was a decision that he made.
And can you talk about that? Because I find that one of the more kind of compelling arguments about causation is that if you look at the trust and say, okay, whatever mistakes they made, they breached the lease, but they're acting in good faith now, assume good faith after the preliminary injunction hearing, and they say, I don't want any more legal fees, I don't want to deal with this anymore, I'm having some questions about my attorney, I'm going to sell the property, because that way, I'm not in this, and the lease goes with the property, and that's going to be someone else's mess, as we heard appellant say. Where is it in that 3 weeks that we can tie, or that the judge in the factual findings ties directly Western Surety's acts with Mr. Galley, such that he should be on the hook for whatever happened during those 3 weeks and the confusion that your client obviously was under with the AG and the city and all of that. But if they were acting with clean hands and they'd really tried to get out from under and said, I just want to sell it because that way I'm out, what's counter to that? How can we decide that Western Surety's continued action with their attorney, who was the same one that Green Cross had, somehow falls back to them in liability for these damages?
Judge Bailey, I'd answer that in 2 ways. So first of all, as Judge McMurdy pointed out already, the first thing we're going to do is look at how to measure damages from the point of the
Oh, absolutely.
Right. So now there's a lot of stuff happening subsequently. All right.
I'm really talking about from the date of, say, the end of June until, July 30th.
All right. So we get through the preliminary injunction hearing, at which point the court issues an order saying that Green Cross is entitled to this property. It is not restored. There had been no close of escrow at that point in time. Green Cross was never restored.
Right.
At the preliminary injunction hearing, if you read that exhibit, there's no discussion about selling this property to Western Surety. Apparently a deed had been signed some weeks previously.
Right, with a different entity, and the judge said that there's nothing, this is just a fake transaction. But that's not who they actually sold to. So again, if you're assuming good faith in the 3rd week in June, and they find a different buyer, and it happens to be affiliated with their attorney, but leave that, they find a different buyer because they want out, and they don't want to have to deal with this anymore.
All right. So here's what you have. As of May 21, Green Cross has been kicked out. Their right to the property has been rescinded to ADHS. The owner of that property fails under order to restore possession and to restore those rights, and now hands off the property to the next buyer under this cloud of chaos and uncertainty that he himself created. And they, Western Surety, merely continued the narrative.
Well, you say continue, but they had to act independently as their own business to say, what are they going to do? And I think you can make an argument that they made an independent decision to also breach the lease, and that was how is that not directly on that company to say, no, you say a continuation, I get it, but I say an independent act, that they acted independently to act in the same way that the Gully Trust did, but it's still on them.
So I'm not going to excuse the conduct of Western Surety, but remember, when ADHS is contacting Green Cross in late July and saying, you still have an issue, you don't have landlord consent and you don't have zoning. Okay, remember now, the reason they didn't have zoning was because of the letter that Green Cross's attorney, or that Galley Trust attorney solicited back in May from the city attorney, and it wound its way to ADHS. That was not a Western Surety action, that was a Galley Trust action. Secondly, with regard to landlord consent, whatever else you might want to say about Western Surety, it took no position inconsistent with the position that had already been established by John Galley and Galley
Right,
Trust.
but they had a right to let Green Cross on their land. They had a right to look at this lease and say, yeah, it's a valid lease, so we're going to let them on the... they had a choice. They chose to continue to exclude your client from that land, but they could have made a different decision. But that decision wasn't Galley's to make. It was Western Surety's, whoever they were.
I maybe would say it a different way.
Okay.
Western Surety had an opportunity to cure Galley Trust breach. It elected not to do that.
Isn't that making my point?
I don't think so. Our damages began, the breach was in April of 2012. Damages to be measured from that point in time. This argument, this notion of an independent cause, of damages was argued to the trial court, and the trial court did not make a finding in support of that. And the trial court heard that argument, the very one that you're making. And the reason that that argument fell on flat ears with the trial court was the fact, as found by the court, that the Galley Trust threw in with this Western Surety group. They paid him, or were supposed to, hundreds of thousands of dollars, and that economic proposition is what ousted Green Cross from the property, kept them out, facilitated the transfer to Western, and in the end, when the lottery rolled around in early August, Green Cross was on the outside looking in. I do want to point out that the idea of an independent intervening cause was briefed and argued to the trial court, and the trial court made no finding of fact to support it.
Counsel, I have a question, and it hasn't been addressed. Has Arizona ever recognized an ex ante approach to the measure of damages?
Yes.
Okay.
And so I'll be happy to, let me address that. This gets caught up in Galley Trust's argument with regard to the lottery ball, and didn't Green Cross merely lose an opportunity to be assigned to a losing lottery ball? In SDR Associates, in that decision, this court stated correctly, quote, damages are measured as of the date of the breach, end quote. And this is consistent with the restatement second of contract, section 348, that deals with a situation where you have a contract that's based in part on a fortuitous act that states that the value of a conditional right should be measured at the time of the breach. That is, in fact, the legal framework that ought to apply in a number of contract cases, including this one. And the Galley Trust, through its expert, Mr. Tribe, conceded that the ex ante approach is appropriate. In fact, his testimony was somewhat humorous on that point, because he says, I don't concede that it's appropriate in all cases, but it's appropriate in this one. And that in order to do that, what you do is you take a forward look at this lottery situation, at this fortuitous act, and you apply a discount ratio. The damages methodology, therefore, is what was known at the time of the breach in terms of the valuation of this contract right. That's what Mr. Duncan studied, quantified, presented to the court across dozens of slides, walked through in detail not only Mr. Brothers' testimony, but his further interviews with management, his studying in Colorado and California, which had mature markets at the time. So in other words, there was a lot known about the medical marijuana industry, even in Arizona, as nascent as it was at that point in time, based on what was going on outside of Arizona, the fact that the state was creating something akin to these mini monopolies by only granting, one per CHA. It provided a wealth of information by which ex ante worked. There was no contention at trial that ex ante was the proper approach. And tellingly, Judge McMurdy, Dwight Duncan tried to stay true to that analysis, but if you read his trial testimony, several times he points out if he had done an ex post analysis, the cultivation area would have been larger, the sale prices would have been higher, the profits would have been bigger. But it was the analysis that he thought was appropriate. It was the analysis that the evidence put on by Galley Trust thought was appropriate, and it was the analysis accepted by the judge. And I think that based on SDR and the other, and the restatement, that it is the applicable law in our state.
All right. Thank you, counsel.
Thank you.
Any final word?
Yes, Your Honor, I wish I had another 20 minutes. I do want to point out on the management fee issue, I was prevented from questioning the single fact witness at trial, Bill Brothers, the owner of Green Cross, on this question because a stipulation was placed on the record that management fees were not being sought as damages. Therefore, Mr. Cunningham argued it was unnecessary for me to establish that the profits would be paid out in management fees because they were not attempting to recover the management fees. I acknowledged in both briefs that nonprofits can recover lost profits or lost surplus, as the case may be. Nonprofits cannot, however, pay their surplus out to a for-profit management company at all under ARS 10.11.302. They can't do that. So these are expenses of operation. These are not surplus or profits that can be used later to pay out to a management company. All of these questions, Your Honors, they're legal questions that I've raised. However, the reason that the briefs are heavy on facts is because these facts that are undisputed and largely stipulated to prior to trial compel a certain conclusion under law that's very established once you apply them to the established law. We're not challenging those facts. As far as the...
It seems to me that you're asking us to reevaluate the facts, whether they're stipulated or not, and apply it to the legal conclusion. But isn't our review an abuse of discretion?
No, Your Honor, because what I'm saying is the trial judge's errors, each one of them, was based on an incorrect legal standard, based on applying an incorrect legal standard. He applied an incorrect legal standard as far as agency and as far as the Exhibit 44 being admitted for a limited purpose, which he apparently had forgotten about by the time he did the findings. He applied an incorrect legal standard as far as the counterfactual universe in which what would have happened if this lottery was run between Green Cross and the medicine room rather than between compassionate care dispensary and the medicine room. That was a legal standard that the judge misinterpreted as something that experts could tell him about. The expert is talking about ex ante, ex post, whether I can consider facts that happened after the breach. That's not the expert's job, and that's why we didn't have an expert on that issue, Your Honor.
All right. Thank you, counsel. The
Thank
matter
you.
is deemed submitted. We'll issue decision in due course.
Thank you.